for Mr. Floyd and Miss Cudy. And I wanted to start with Miss Cudy, but we're trying to double check to make sure she actually got notice. And was there anyone here from the state that was going to be handling that? I don't see anyone.
Your Honor, we're here via Zoom. Grant Root and Alex Burnick.
Okay, I hear you, Mr. Rude, and hang tight with us. We'll see if she will be joining us and if she got proper notice, and we'll be back with you, okay?
Okay.
Okay, moving on with Mr. Floyd. Let's have counsel for the record here just introduce themselves so we know who's here and if we've got everyone we need to have.
Christopher Kachuroff and my colleague,
Todd A. Harding.
All right, welcome back. All right, and I see the defendant is present as well. And we have, on behalf of Fulton County and the clerk's office as well.
Yes, Judge. Chad Alexis and Kay Burwell, Your Honor.
Okay,
Good
well, welcome back, Mr. Alexis and Ms. Burwell. Okay, so let me just kind of bring everyone up to speed, make sure I still am refreshed on everything. We're here on some third-party subpoenas originally issued by Mr. Floyd back in October. We had an initial hearing in November, if I'm not mistaken, where there was a consent order worked out between the Secretary of State's office and Mr. Floyd. And then we met again on February 19th and February 13th, still to try to work out the particulars of exactly what it is being requested, what still needs to be transferred over, and kind of the logistics of how that was going to work. And then I was informed about a month ago that it appeared the parties were at an impasse and things had broken down. And so I think Mr. Floyd at this point was requesting, I think it was 8-witness kind of hearing with some expert testimony. And before we crossed that bridge, I wanted to kind of preliminarily check in to see what caused the breakdown and what would actually be discussed at a hearing and whether we need to have one. So, Mr. Kucherov, it's your subpoena. So if you want to kick it off, you can go through the procedural history as well if you want, or you just want to jump right in and tell me where we are today. The floor is yours.
jump right in, Judge.
Okay.
So the county and the defense here, Mr. Floyd, disagree with respect to the production. I feel like the county does not really want to produce these things. They made representations in a filing about, I don't know how many years, like 27 or 37 years it would take to get this information. And if you started to break it down, it becomes kind of absurd. The other thing that I have mentioned in some of my emails and why I thought this status conference was premature is that I have a difficulty in formulating a defense. We have a difficulty formulating defense for Mr. Floyd when we don't know what the facts of the false statement are. That informs my discovery. It informs the discovery against my colleague on the other side for the county. How is he supposed to defend his client when he doesn't know? He can't make a relevance objection because he doesn't know what's relevant and what's not because we have no facts. The court will recall we had that hearing about a week before the disqualification hearings. And I know that you've been busy and you've got a lot of things on your plate, but I would submit to Your Honor that all of this will likely be unnecessary because there is no false statement. I believe once the court looks at that issue, it doesn't take long, that you'll dismiss. Perhaps I'm being presumptuous, but I think you're going to dismiss this case. It's probably the easiest one I've ever seen. So how does that relate to all this? Obviously, if I don't have the facts upon which my client's being accused, it's harder for me to engage in discovery. I've got a lot of discovery I want to do, but I don't even know if I think what I have for the county is sufficient. If you want to just handle that today, I suppose I could, but it would be nice to be more focused myself to know.
All right. Well, I'll grant you and I'll agree with you that I owe you some rulings. And I'm planning to dive in and hopefully be able to get you and start going through those throughout the summer.
If I may,
Mm-hmm.
with great respect, the issue is pretty simple.
Well, we don't need to relitigate it. The state's not here.
Relitigate it because the state's not here, and I'm not trying to relitigate that.
But here was going to be my point, was that I hear your argument that you need more clarity in your special demur. This is
Sorry.
Well, if it's special, if you're wanting more information, right? You want to know
no.
exactly what the false statement is.
No, a general demur is a device from the common law. It's an arcane pleading, as you know, where you can admit the facts as pled in the indictment and the law that's there, and you're still shown to have committed a crime. That's a general demur. A special demur does seek additional facts. I'm not seeking any additional facts. What I'm suggesting to the court is, as the person responding on demur, I'm not required to accept conclusions of fact. So there's no facts in the indictment for me to admit on the false statement. Zero. Not a single one. That is a general demur. You can't just say somebody committed a crime and not say what the facts, a bare bones set of facts that are sufficient to support that crime. That's a general demur.
Okay.
And you'll see, I put that in my brief. I'm not asking you to look at it now, but
I've got it. I've read it. But more to the point was this inability for us to go forward with getting into the particulars of the subpoena. We were fine the last 3 hearings where you weren't asking for that information. It seemed like you wanted to know anything and everything related to Fulton County in the 2020 election. So it's only now that we've got that issue pending that now we're supposed to just stop until I'm able to get you a ruling on that. And so that's where
one is it's a matter of efficiency, and as I keep going down this path of trying to formulate a defense, it becomes so much more difficult to speculate on what type of evidence I need. So true it is that we asked for a lot because count 1 is a lot. But the moment I started to think about what this false statement could possibly be, because I'm not a mind reader,
yeah.
you know, I don't know what the false statement is, it became more prominent in my defense. And so I'm trying to figure out, do I really need this stuff, or is that sufficient? So with that said, Judge, that's my, I think that's the posture of where we are now. Having said that, the county, and for that matter, the Secretary of State hasn't turned over. They're starting to play cute with the terms of the subpoena that we agreed to. So I'll be bringing that back up if necessary. But that's the whole key is it necessary right now to do all this? I don't think that it is.
Okay. And if we proceed from the original framework, though, that the reason you want these records is to prove the truth that there were irregularities in Fulton County, and that's what your client was concerned with, which is, again, I think what was your briefing of why this is relevant a few months ago.
Under count 1.
Which is, it says it right there that he did not win, right?
Right.
And so that was the relevance hook that you had initially.
Correct.
What is it? I'm trying to remember from the email you sent a few weeks ago, you were saying that Fulton County had not turned over anything yet, and also that you were now declining to pay any expenses in advance.
Right. I don't think my client should have to bear the costs. He's facing 37 years. The county has all these resources. They're the ones bringing the charges. You know, they have to turn it over. And these are liberty interests that are at stake. And I just, you know, at this point, because it's taken so long to get the information to begin with, we're looking at other resources to try to match up a defense, and I just can't. I'm having trouble doing that. So,
okay, I can respect that. I can sympathize with you. We are obviously throughout the system one of limited means, but that might be a hurdle that we just have to stop right at from the beginning. Which is when I look at the statute, especially when it's a production as large as the one you'd initially asked for, even in your amended subpoena, which I don't think we ever filed, but you'd provided me, and we'd gone over it in detail the last hearing. Even in the amended version where we were giving and taking in the last hearing, it's still going to take some time. It's still going to take resources. And the statute, as I read it, says that that's not a burden that should fall on a third party.
We will be glad to, well, this is not a third party. This is Fulton County. I mean, it's still part of the DA's office here. You know, they may be a separate agency. I get it. Right. Or separate, but there's still one political body, Fulton County, period. I'm happy to tell the court, we'll have our own people do all the copying. We'll have our own scanners, all of that stuff. But there's not going to be any outlay of expenses on the state, especially since a lot of the stuff I'm learning now has already been produced in other forums. And that's what I want to investigate further. So that's an issue. So if we were to have another hearing on this, I would have witnesses come up and say what the county has turned over in the past, what it hasn't turned over, what the county has, what it doesn't have. I would have an expert witness or two testify to the fact that, hey, look, getting the logic and accuracy testing of the machines, which is required under Georgia law, getting the proof of that is not difficult. It's not a 100-hour task. It's a 30-minute task because you should just have to locate the file. That's it. So from my perspective, that's where we are. That's, if that makes sense. And so what I had offered before was to pick up a machine and let the county use it. What I'm suggesting to you now is I want to have first want to have hands-on. I want our people to look at it and to be able to copy and inspect as they need to.
Okay. All right, let me turn it over to Mr. Alexis, and you can take up any and everything from there that we have to have. But what I'm hearing is that the issue of just down to the mechanics is there really hasn't been any kind of an agreement between the parties on that. And so I'm really not hearing a way around getting into the details and wading into it.
Understood. Judge, I'd just like to say for the record that the county is not bringing the charges. The district attorney is bringing the charges. She is the DA of the Atlanta Judicial Circuit. That circuit just happens to be conterminous with Fulton County. But as we all know, DAs act in their scope of prosecutorial discretion, acts on behalf of the state. They're state officials. As for the breakdown, so Judge, we were amenable to receiving the machines that Mr. Kirchhoff offered, not the software. And of course, you know, Fulton County had a cyber incident earlier this year, so we're especially vigilant when it comes to things like that. So we will take the machines, but not the software. Now, Judge, as for the relevance, I just want to briefly touch on that again. Again, they're asking for information that they did not have access to when the statements were made. If they're saying that this information was the basis, reason, or cause for the statements, that cannot be so because they did not have the information. But I think Mr. Kirchhoff is correct when he says that we need to know what the statement was or he's being accused of, because it's hard for me to say, well, this is not relevant, or say, well, okay, this could be relevant if I don't know what the statement is. If the statement is, hey, X won the election and Y lost, then fair enough. If the statement is, hey, tell them that you saw someone destroying ballots, we don't need to go through all of these things to prove whether or not that's true. And again, I guess by their own admission, saying that, you know, they're just guessing as to what the statement would be, and that's what caused the request in the subpoena. It just shows that the subpoena is a fishing expedition, Judge. It's not pointed towards anything in particular that they're trying to narrow in on, because again, they don't even know what the statement is. So they can properly argue it, we can't. But the one thing we can say is that the information that they are seeking to get is information that they did not have access to at the time of the statements. It is inconceivable that is relevant.
So what about the idea, set aside the substantive counts that talk about specific statements, and then we're kind of retreading ground from a few months ago, but count one is the RICO count, which applies to Mr. Floyd and simply comes out and lays the standard as being one person won the election, one person did not. That was the basis, the original argument for why anything and everything was relevant. And so if that is still the standard, then where do you go from there?
Well, there are two things to consider with that, Judge. The first, obviously, is, as I said, they didn't have that information when they made the statement. So the question becomes, why did you make the statements? And they can't say, well, look at these documents. It's like, well, no, you didn't have that at the time. I think that should draw a relevance objection in a courtroom. The second thing, Judge, hearing, or I believe the hearing before that, the defense said that if the evidence showed one thing, they will go in one direction. If the evidence showed something else, they'll go in another direction. Judge, again, by all accounts, that just shows that they are guessing at what the evidence will show. So it's not as if they made a statement or they're being accused of making a statement. They're standing on it. They're saying, hey, we made this statement, whatever it may be. If the evidence shows that we were right, we will roll with it. If the evidence shows that we were wrong, we're going to make another argument. And again, as I mentioned, Judge, if it doesn't bear on their innocence or guilt, if it doesn't matter what the evidence shows, they're still not guilty, then I don't see how it's relevant.
Sure, but shouldn't they have a right to present their strongest defense?
Well, I can't speak to what they have a right to at this moment because this is in the midst of a quashal. And from my understanding, the only issues that is relevant to a quashal is whether the information sought is relevant and whether it's burdensome and oppressive. As to what they may be entitled to, something that they will have to make an argument for. And I don't think a quashal is the appropriate forum.
Okay, and so at this point, Mr. Alexis, based on the last hearing, what they had narrowed down to saying they don't have an argument with what's saying they do. You know, I think we had still, I mean, I think I remember us going line by line and talking from my notes here. There are only a few items that really were kind of the sticking subjects. Has the county come up with any revised or updated version of just exactly what it would take to comply with the subpoena, or the resources that would need to be marshaled?
No, Judge. We left off where we left off at the last hearing. Mr. Kirchhoff made his offer. We cannot accept the software. We can accept the machines. We can't say for sure how long it will take for us to produce information with the machines that we may or may not receive from Mr. Kirchhoff because we don't know what they are. We've never used it. We can't. We're just going to be speculating. So as of this moment, no, we don't have any changes. But I do want the court to keep in mind a few things. One, we're in the middle of a presidential election right now. So it's an all hands on deck situation. The second thing is this information is actually being housed by the clerk, not the elections department. The elections department offering assistance is merely a courtesy. So if the court were to just put this on the clerk and the elections department took a laissez-faire approach and said, hey, you guys figure it out, you're the custodian, this will take probably 10 times longer because you have individuals who do not know what they're looking for. The clerk simply houses the information. The elections department, they are the individuals who are actually the experts when it comes to elections and finding this information. Now, as for the numbers that were listed here, Mr. Kirchhoff, his assertion is that they're absurd. And I get that the numbers do present some sort of sticker shock, but just to give an example, the absentee ballots, the applications, Judge. Those are what, over 800,000? If we're talking about printing, we're talking about redacting, and we're talking about reprinting, because if you do the magic marker, there's a chance that it can still be translucent. You have to reprint it to ensure that the confidential information of the Fulton County citizens are not being dispersed. Just that process alone is going to take thousands of hours. Now, if we're talking about getting batches and batches of individuals to assist with that, that will cost money. And again, the county should not have to bear the burden of that because the county is not a party in this. And to reiterate my first point, the DA brought the case, the state official brought the case, not Fulton County.
But you still haven't told me just how much money or just what it is you would need to make some of this happen.
So we did submit the information on how much it will cost. And we had two witnesses the last time. We had Mariska Bodison and we had Derek Gilstrap. For Mariska, her hourly rate is $33 an hour, and for Mr. Gilstrap, it's $27 an hour. So it's just a matter of extrapolating that across the amount of time it will take to produce the information. And as we mentioned in the last hearing, Judge, it may take less time, it may take more time. It's really hard to say at this point.
And so what was the extrapolation based on your current calculations?
Well, we didn't do the math on that because the two major ones that we were concerned about, which was number 45 and 44, I think one was 57,000 hours, the other one was 10,000 hours. We were supposed to work that out through software and things of that nature, which of course we had to break down. But Judge, I can go do the math for you right now and come back with a number based on all of the hours that we have written down here.
Sure. So other than 44 and 45 on the amended subpoena, that's something you are able
and number
to provide that quote.
And number 14, Judge.
14. That's right, 14. Okay. And so, Mr. Kucherov, turning it back over to you, would you say 14, 44, and 45 are still the kind of primary points of contention that are causing, or not so much causing, is that you would say are miscalculated?
Absolutely. I think it all is miscalculated. It's all overblown as again.
Well, I mean, one of these is
situations with the clerk's office.
1 hour.
I've got experts
Yeah.
that can go in and probably do a very efficient job of looking through the material. So if the clerk's office is the one who's housing all this and he has no objection to it, why can't the court just order that? Just make it subject to a protective order. So if there is any confidential information. It's not PII, by the way. There's no PII. I've checked the Georgia statutes. On the absentee ballots, there is no PII. I've got software developers who, when they scan it, can make sure that it's redacted so that if you decided just sua sponte of your own accord that you wanted to there was a phone number that you wanted off, my guys could do it. They could actually produce a PDF with that blacked out, that redacted part out. I don't think we need to do that, but I think we have the right to inspect and look at this ourselves. I don't have to rely upon them. If they don't have it, they should just say it. Just like the signature verification we now know did not occur in Fulton County, required by law in order to certify. So there was no signature verification. And then we know this because the Bluecrest machine was not operational, wasn't working properly. And that's what they used to scan these absentee ballot envelopes. So we can come in and we can scan the envelopes anew. There's no need we just have to have somebody in a room. You can have what takes one person from the county to be there. We can be there for 8 hours a day. And I guarantee our guys get it done very quickly. It won't be this like number 44. 57,334 hours. Just look at that. With the number of ballots that I understand are mail-in ballots, 148,219 mail-in ballots. That's an estimate of about 2.58 envelopes scanned per hour. Okay. Under their estimate, that's $1.1 million to scan. That sounds grossly high to me. So stuff like that. I mean, so all of this can be taken care of. We can take care of that. I'm willing to do that. We can bring the scanners in, we can have our people scan it. You just need access to the docs. If you want one of the attorneys there supervising, make sure nothing gets taken out, I'll do that. I have no problem doing that at all. But we do want to get access to this so we can begin to compile that defense to count one.
Judge, can I add something?
Sure.
So we did mention that we did not use the Bluecrest machines. We at no point in time state that signature verifications was not done. I don't want to make this a point of contention at this point because that's not what we're here for. But I'd just like to correct the record on that part. And as for the amount
And how did you correct it? Just
but
what did you say?
we did not at any point in time state that signature verifications were not done. We are just saying that we did not use the Bluecrest machines. And I'd just like to put that on the record.
Okay.
Judge, as far as the amount of money is concerned, I mean, you look at the BOC hearings, you see how much money goes into actually running an election. And that's because it takes all of this manpower to do all of these things across these hundreds of precincts. So you take one person, make them do all that work. And, for this one case, it will take a very long time unless you're going to replicate the situations or the circumstances of an actual election and hire hundreds of people to do so. Yeah, it will take this amount of time and it will cost money.
Okay. Well, I think at this point, y'all have set the stage for what needs to happen next, which I don't think can be avoided without coming back. So what I would propose that we do is I'll again consider the points on relevance, consider the points on defense counsel's demur on the counts where it relates to the statement, and then what I think would also narrow the focus and make sure we proceed efficiently is I think the amended subpoena, and if there's some kind of mechanical proposal that you're saying is the most efficient way to proceed, I think that needs to be made part of the record. So I would say that you need to file an amended subpoena with everything that we had talked about at the last hearing of exactly, because I think there were some things, as I remember from my notes here, that you had said, well, we don't need that one anymore. We don't need this anymore. So I want to take a very close look and make sure we're on the same page of exactly what it is you're saying you still want and you still don't need, assuming that count one is still what you're contesting on that broad kind of overarching statement. And then when it comes to just initially the mechanics of how you would propose going about this in the most efficient manner, you can lay that out as well. So then the county would actually be on notice, can respond, and we can move on to the next step of exactly determining what it is that needs to take place for you logistically to get these things. And I would still be conditioning, if it's granted in some form, it's still going to be conditioned by, as outlined by the statute, on payment of some form of the cost in advance. That's what the statute contemplates. I don't think that there's a meaningful distinction there, that the DA's office can just be lumped together with that same governmental entity. But we can't do that until we know exactly what it is, how we calculate those costs and how we can come to them. So I think both parties are very far apart on that, and that's what we're going to have to figure out. So, Mr. Kucherov, you had mentioned needing to get kind of availability for your experts. Have you been in touch with them? Do you have some general idea of their schedule?
I think sorry, Your Honor, month of June is fairly taken up right now, but I can probably squeeze a day or two in. I talked to the experts, they've got some time at the latter part of June and also into July.
Okay, that's what we'll shoot for. And when can you kind of file something along the lines of what I was outlining?
Weeks?
All right.
Judge,
Mr. Alexis.
I get a scope of what these experts will be testifying to.
That is not unreasonable. And so, Mr. Kucherov, if you could outline that in your filing as well.
Absolutely, I'll do that.
All right. And I think generally with our standing order, when we talk about experts, we talk about providing a CV and just a succinct but meaningful summary of what it is they would be testifying to. So that if Mr. Alexis needs to rebut that with his own experts, he can do the same and provide similar notice. All right. Anything else that we think we need to address today as it relates to the subpoena? I know this is more of a kind of pre-hearing conference of sorts, but I think we needed it to at least see where we were and get back on track. Anything else, Mr. Alexis?
The county judge.
All right, Mr. Kucherov.
No, Your Honor.
All right, we'll follow up by email, and I hope to have that guidance for you as we go forward. All right.
Maybe one other motion then.
Well, that was with Miss Cudy, or is there something else?
Well, there's the motion to unseal, but we kind of.
Oh, okay. Where were we on that?
I think our position was just to make the court aware that some of those items may be sealed, and if court was going to allow access, you'd probably need to unseal them and then enter a protective bid.
So, for me, I'd been lumping all these together. They were all kind of part and parcel. Is that about accurate?
Yes.
Okay. And so until we figure out whether the subpoena is going to be granted, there's no need to get to the motion to unseal.
Correct.
All right. And if so, those would all follow one another.
Yes.
All right. Sir?
With the motion to unseal, again, I know the county is a third party, but because the county actually houses the information, we would have liked to have been privy to that. I know I saw the motion in the flurry of emails and filings, but we weren't exactly noticed for that argument. So, you know, whatever dealings that will be taking place as far as that unsealing will take place, the county would like to be kept in the loop.
Well, we haven't really discussed it at all. You're as much in the loop as anybody else right now. I don't think we've actually substantively argued it. It's only ever been on a calendar the same day that you are, and there aren't any emails talking about it going among the parties. So if that's something you're also looking to intervene on or believe you have standing to, you still can. And like I said, I've just been treating it as part of the subpoena issue. And I'd also been treating you, because I think this is where we landed back in the November hearing, as really being the spokesperson for the clerk's office on this issue as well, the subpoena and any unsealing issues.
Judge, I actually do represent not only the elections department, but I also represent the clerk's office. So
Right.
it worked out in that regard.
Okay.
But I will say for the Board of Registration Elections, which I represented up until, I want to say a few weeks ago when we got outside counsel, Judge, I will say that one of our first arguments, I mentioned that the BRE is not the custodian of the records being sought. So we did ask for the BRE to be dismissed from that. I was under the impression that the court did that, but I did see their name come up again for today's hearing. So I'm not sure where we are with that, but again, they are not the custodian.
Right. And that was because the subpoena was directed to both
Yes.
entities. And you were telling me today that if the BRE is released from this, they're the only ones with the subject matter expertise to actually know what to be looking for within the clerk's file?
Not the BRE, Judge, the department, the elections department.
Excuse me. Okay.
It's an interesting trail that the BRE directs the elections director as the election supervisor and chief administrator, and that's pursuant to state statute and county ordinance. And then the elections director, as the director pursuant to being hired by the county, have, I guess, supervision over the department.
And so the elections department does fall under the umbrella of the Board of Registration and Elections, though.
Not really the department, but the director.
Okay.
Because the director reports to the BRE, the staff does not report to the BRE.
So to keep the elections department involved in this, are you saying they're not a party to this?
No, Judge, and as a matter of fact, if you do want to serve the elections department, because they're an entity incapable of being sued, you'd have to subpoena the county itself. Because the clerk can be subpoenaed separately, so can the BRE, but individual departments, correct me if I'm wrong on that one?
Yeah.
You'd have to go through the actual Board of Commissioners. But regardless, Judge, the elections department is staying in and involved in the event that, we have to pull some of the documents, because to remove them now is just gonna be sort of slowing down any process or progress, because we asked to be removed, we can easily be added back in later on. So, it's gonna be form over substance at that point.
Okay. And so your point would be that
That
the Board of Registration and Elections was the improper party to serve because they don't have custody of any of the documents that were requested.
Yes, Judge, and I
Okay.
really would like for them to be dismissed under the caveat that we will still have the elections department involved to assist where we can, if need be.
Okay, Mr. Harding.
I think we withdrew that subpoena at one of the hearings, Your Honor.
All right, I just need to make that, I'll just make that part of the record formally through an order.
That would have been a shorter way to,
I'm sorry?
that would have been a shorter way to get to that.
Okay. Well, there's the short way and the long way. All right, so that's withdrawn formally by counsel.
Yes, sir. I
Okay.
think we did it at one of the prior hearings, but we do it again if we need to.
No, that's fine. I just need to make sure that that's memorialized on the docket, and I'll do that. And so that's position 3. So when we come back, it'll just be on 1 and 2. All right, thank you for that clarity.
Thanks, Judge.
Okay, we'll be off the record as it relates to Mr. Floyd, and take care.
Thank you.
Let me check in. We'll see if Miss Cudy was able to join. She was able to join us? All right.
I am here. Yes, I am here.
Okay, thank you, ma'am. If you could turn on your screen,
Okay.
and then we'll see if we can make it so we can see both you and representatives from the district attorney's office.
I actually had my screen.
Okay, just hang tight for a second. We've got to make sure we can see you in the courtroom here. Okay. We're still not seeing a screen on our end. Might want to check your settings.
I am doing that currently.
Okay.
Okay. Am I there?
Not yet. We just part of the, even if it's a blank screen. Yeah, just add it to it.
I may have to go out and come back in.
Yeah, why don't we give that a shot since I don't think we're having any luck here. Oh, there we
Am I
go.
here?
Yes, we can see you now.
All righty.
Okay, so it sounds like you can see and hear me all right.
I can.
And am I pronouncing that right? Is it Miss Cudy?
It's Cudy.
Cutie, excuse me.
No
All right,
problem.
so, and Mr. Rude, can you hear me all right?
Yes, Your Honor.
Okay, then let's go back on the record. This is now with Miss Cudy, and we had noticed it today with the offer of a remote hearing just to check in on the status of counsel. So Miss Cudy, you'll remember we last met on January 12th just to check
Correct.
in, and your attorneys had withdrawn private
Mhm.
counsel. And I'd
Mhm.
asked you back then whether you were interested in getting public counsel and applying to see whether you qualified for that. And you mentioned that no, you still wanted to try and hire private counsel.
Correct.
And to date, I'm not seeing anything on the docket that says that you have hired private counsel. So the first thing I would ask you about is what your plans are, if you're still wanting to hire private counsel, if you want to apply for public counsel, or if you want to represent yourself.
Well, Judge, I'm not for certain why you don't have counsel on record because my counsel filed on April 26th. The clerk is Shay Alexander. My counsel has been on record. I don't know why the state has not become aware of that.
Well, we've got a lot of dockets. Let's check to make sure it got on there. And if nothing
Okay.
else,
Your Honor.
we just want to confirm that an entry was made. Yes, sir, Mr. Rude.
Yes, Mr. Donaldson, George Donaldson did file an entry on Miss Cudy's behalf. But in the docket for Mr. Trump, he didn't file it under Miss Cudy's.
I see.
We have reached out to Mr. Donaldson to exchange discovery. So we're in communications with him.
Okay, excellent. So we just have a little bit of a technical complication there. So, Miss Cudy, so George Donaldson is your counsel of record. That's who you retained?
Correct.
All right, excellent. So it sounds like we just need to make sure his entry gets on the right docket. That's just a little bit of a filing error. But sounds like the state is in touch with him. And from here on out, he should be getting notice of these and he should be here next time. You shouldn't have to speak on your
I
behalf if you
actually
don't want
found
to.
out about this hearing on Twitter. I was getting a massive amount of, pings on Twitter about a hearing. I had no idea about it.
Okay, well, I
He
think,
didn't either. He had no idea either.
got it. Well, once he is filed into the right docket, then we'll know where to send the notices and we'll
Gotcha.
clear that up and it shouldn't happen again. But that is all we needed to handle today, Mr. Rude, unless you think there's anything else we need to do while Miss Cudy is here.
Nothing from the state, Your Honor.
Okay, thank you for joining us. That's all
Thank
we got,
you.
unless you have a question for me.
I do not. Thank you, Judge.
All right, take care.
Bye-bye.
All right, court will be adjourned.